I recognize the pain. I can only imagine if my wife, my daughter, did not come home one night.
This was the most selfish, self-centered, evil thing that I've ever heard.
In an emotional court proceeding, Judge William Atkinson sentenced David Meyer, a De Pere man, to 10 years in prison for driving under the influence and causing the loss of Rebecca and Rayleigh Pennenberg, a mother and daughter who were walking along Lawrence Road in August of the previous year.
I didn't know the family, had no connection, but I've seen too many of these cases, and I've seen too many people suffer from drunk driving.
The judge, moved to tears, expressed the profound impact of such tragedies and empathized with the victim's family.
I recognize the pain. I can only imagine if my wife, my daughter, did not come home one night.
Meyer, who had a blood alcohol content of 0.22, nearly 3 times the legal limit, apologized in court, acknowledging the irreversible harm caused by his actions.
There's nothing I can say that's gonna ease their pain. There's no words I can say to give them any peace.
He stated that he thinks about the victims daily and expressed a desire to use his experience to educate others about the dangers of drinking and driving.
I've been and will continue to give people the understanding of what it means to drink and drive. I continue to tell everyone I meet that when you drink, the first thing you lose is your judgment.
Despite his remorse, the victim's family declined to comment on the sentence. This is Gregory Wright, a 22-year-old suspect in an armed robbery in Detroit, Michigan. According to reports, Wright threatened Gregory Gretton and took his car by force. During his escape, he crashed into a police cruiser and fired, injuring an officer in the arm. Wright was arrested the next day, on June 29th.
All I got to say is I have no remorse for that police officer. He got what he deserved. If I had the opportunity to kill my...
If I had the chance to kill him, I'd do it, Wright said. He went on to express. Now in court, Gregory Wright faces charges of armed robbery, carrying a concealed weapon, and using a firearm during a felony. During a pretrial bond hearing, Judge Aubrey set his bond at $50,000. Upon hearing this, Wright attempted to flee the courtroom. After a scuffle, 7 officers finally managed to restrain Wright. Judge Bray revoked his bond and ordered him to remain in custody. The case later went to trial, where Wright was sentenced to life in prison. Timothy Jones Jr., a father from South Carolina, was charged with murdering his 5 children. During the trial, it was revealed that Jones admitted to causing his son, Natan, to lose his life by forcing him to exercise until he could no longer survive, following an argument over a broken electrical outlet in August 2014. After the incident, Jones spent hours deciding what to do, leaving his other children at home with Natan's body while he went out with his oldest child. He eventually chose to end the lives of all of his children. Jones wrapped their bodies in plastic and drove around the southeastern U.S. for 9 days, engaging in various activities and making erratic trips while transporting the bodies. During this time, he researched non-extradition countries, carried his passport, and looked up ways to accelerate body decomposition. Disturbingly, he also played his oldest daughter's favorite song, Butterfly Kisses. According to his confession and phone records, Jones later dumped the children's bodies in garbage bags on a hillside near Camden, Alabama. He was arrested during a traffic checkpoint in Smith County, Mississippi, after an officer noticed the smell of decomposition coming from his vehicle, leading to the discoveries of his horrific crimes.
It was 2 patrol cars, a black Escalade. As I was walking up to the black Escalade, I noticed a foul odor, and I asked, "What is that smell?" And they said it was coming out of the vehicle. It was a smell of decomposition. It's a smell that you don't
The defense argued that Jones's damaged and diseased brain impaired his ability to understand right from wrong at the time of the murders, suggesting he was insane. They pointed out that the children were not malnourished and didn't show signs of ongoing abuse, implying that his mental state and difficult life circumstances may have played a role in his actions. However, this argument was not accepted by the court, and the jury found Jones guilty of the brutal murders of his children.
As to indictment 189, Elias, guilty. 190, Abigail, guilty. 191, Gabriel, guilty. 195, Natan, guilty. And it is so signed by the foreperson this 4th day of June.
The jury handed down the death penalty. On July 21, 2022, the Rochester Police Department was involved in a violent confrontation with suspected gang members while searching for the man responsible for taking the lives of 2 men just 48 hours earlier. The 2 officers who were sent to find this man ended up getting hurt, with one of them sustaining a fatal injury. The perpetrator, 21-year-old Kelvin Vickers, had taken the lives of 25-year-old Mel Rand and 19-year-old Ricky Collin, who were caught in a gang turf war. However, it was later discovered that neither Mel nor Ricky were involved in the gang conflict and were just heading to a music event. After the incident, officers Anthony Merowitz and Tino Sang were sent to patrol the area in an unmarked vehicle. Vickers, waiting for the police to show up, ambushed the officers when he saw them. He walked up to the back of their car and fired through the glass about 16 times. Sino was struck in the ankle, thigh, and shoulder, while Anthony was hit at least twice in his upper body and other areas. Both officers were rushed to the hospital, but Anthony later passed away. Vickers was found an hour later, hiding under a crawl space, armed with a loaded weapon, which police believed he intended to use to attack more officers. He was arrested and charged with the murders of Mel and Ricky, the aggravated murder of Anthony Merowitz, and the attempted murder of Sino Sang. Vickers' trial was long, and his sentencing was delayed, but on February 29, 2024, he was finally sentenced. As part of the process, the victims' families were given the chance to share impact statements.
It's a number. Now you have no name. You were Kelvin Vickers before, but now you're just a number.
Anthony's widow spoke in court about her husband's bravery and honored his memory. She then turned to Vickers and called him a sad excuse for a human being. She asked the judge to give him the maximum sentence with no chance of parole. The mother of Vickers' first victim, Richard Colling, also gave an impact statement. Throughout all the emotional statements, Vickers remained unmoved, showing no remorse for his actions. In the end, Vickers was sentenced to life in prison without the possibility of parole.
Due to the chaos of the area, did not intentionally officers, Mazurkowitz and Sang, or Adam, as you said, should or should not have known.
As you just saw, Kelvin smirked, smiled, and showed no regard for the emotions of his victims' families. Even when given the opportunity to speak at his sentencing or apologize for his actions, he refused and was led away. Julio Cesar Rivera was sentenced to 455 years in prison after pleading guilty to a series of crimes, including 5 armed carjackings in 2021.
As soon as they said that it was 45 years, I just started crying because it's not just for me, it's for the other victims as well.
Among his victims was Alana Castaneda, whom he injured in the face during a failed carjacking attempt.
Just to find what I did, nothing's going to make it sound okay.
I appreciate that his parents might think he was put up to it, but these were his choices, these were his decisions, this was his.
Rivera's sentence was reduced due to his guilty plea in 3 cases, including Castaneda's. Despite his apology in court and claims of personal growth over the past 2 years, the severity of his actions, including his use of a firearm, left an indelible impact on his victims.
I got a lot of time to sit here and think about what I've done. I'm not the same person I was 2 years ago. And I pray every day for forgiveness and just for being good health.
Castaneda expressed relief at the sentence, feeling it served justice not just for her, but for Rivera's other victims. She continues to face physical and emotional scars, having undergone 3 surgeries with another pending.
Yes, I was listening to him, but at the same time, it's you did what you did.
Rivera's family sought leniency, citing his troubled upbringing and negative influences, but the court emphasized his personal accountability for the violent crimes. Next up, Brenda Delgado, a woman who orchestrated a shocking murder fueled by jealousy and revenge.
Passion in Dallas. Brenda Delgado, the mastermind in the murder-for-hire plot targeting a Dallas dentist, today convicted of capital murder. Delgado hired a hitman to kill her ex-boyfriend's new love interest, Dr. Kendra Hatcher, in an uptown parking garage.
On the evening of September 2nd, 2015, 35-year-old Kendra Hatcher lost her life in her parking garage during an attack by a suspected robber who fled the scene in a black Cherokee Jeep. An eyewitness heard loud noises and called 911, leading to shocking revelations. Hatcher had been dating dermatologist Ricky Paniagua for a few months, and the couple had plans to get married. However, Hatcher was unaware of the obsessive nature of Paniagua's ex, 36-year-old Brenda Delgado, who had been stalking the couple after her breakup with Ricky a few months earlier. Delgado had been in a nearly 3-year relationship with Paniagua, but they split in February 2015. Despite the breakup, they had remained in platonic contact. However, Delgado's intentions were far from innocent. An autopsy of Hatcher's murder quickly revealed that her demise was not the result of a robbery gone wrong, but a calculated murder attempt. This narrowed the list of suspects down to one: Brenda Delgado. Delgado had recruited 2 individuals to carry out the murder: 31-year-old Christopher Love, a local substance dealer who was responsible for the firing, and 23-year-old Crystal Cortez, a single mother who drove the getaway vehicle. Delgado bribed them with cash. She had borrowed the getaway vehicle from a friend, Jose Luis Ortiz, who was with her on the night of Hatcher's murder. After recognizing his Jeep in the news, Ortiz contacted investigators to inform them that he had loaned it to Delgado, but that she had been with him that night.
You were commenting like, hey, have you heard about that dentist that got shot in Uptown Dallas? She'd say no. She'd say, well, how funny, because I mean, it looks very similar to mine. I'm over here lending you my car.
When invited for initial questioning, Delgado told investigators that she had lent the Jeep to Cortez, which led to the arrest of Love and Cortez. Both Love and Cortez eventually chose to testify against her.
$100.
And who paid you?
After her hitman was apprehended, Delgado faced ominous consequences. She fled to her native Mexico in an attempt to escape justice. However, after being named in the FBI's top 10 most wanted female fugitives, with a $100,000 bounty on her head, she agreed to be extradited to the United States on the condition that she would not face the death penalty. Once extradited, Delgado went to trial on June 7th, 2019, and it didn't take long for the jury to convict her on charges of capital murder. She was ultimately sentenced to life in prison without the possibility of parole.
You can't even look at me. Delgado refused to lift her eyes, but was forced to listen as Dr. Hatcher's sister confronted her from the witness stand.
During Delgado's trial, Jennifer Escobar, a former friend and roommate of hers, revealed that Delgado had been obsessed with Paniagua and had long been planning to execute Hatcher, and possibly even Paniagua himself.
Get rid of Kendra Hatcher.
And why did she want to get rid of Kendra Hatcher?
Because she was envious.
During her sentencing, Delgado maintained a cold, emotionless expression as she was sentenced to spend the rest of her life behind bars.
Jury unanimously find the defendant guilty of capital murder as charged in the indictment. Yeah. Thank you, ma'am.
During the victim impact statements, Hatcher's mother, Bonnie Jameson, told Delgado that she had earned her place behind cold steel bars for the rest of her life. She added a damning statement saying, "If justice could have handed you a death sentence, make no mistake, I would have been there front and center."
Earned your spot on this earth behind cold steel bars for the rest of your miserable, pathetic life.
Today, Delgado is incarcerated at the maximum security William P. Hobby Unit for Women in unincorporated Falls County, Texas, where she is expected to remain for the rest of her life. As for her murder accomplices, Love is currently on death row for carrying out the murder, while Cortez was offered a 35-year sentence in exchange for testifying against the other two. When Lawton woke up, confused and worried, his son fired at him from close range. After taking the lives of his whole family, Trey wrote disturbing messages around the house, one of which said, "I love my mom, dad, and brother. God forgive me, because I cannot forgive myself."
Everybody was scared about if it was going to happen or not. Everybody's paranoid. Family members were at the home today collecting sentimental items. Investigators say besides the gore...
Despite the violence, Trey wasn't done. He loaded his black Ford Mustang with a rifle and hundreds of rounds of ammunition, then drove to Waller High School, his former school. He parked his car and sat in the lot for a while, thinking about his next move. However, instead of carrying out the mass attack he had planned, Trey eventually drove to a friend's house. By the time he arrived, his parents' bodies had been discovered, and Trey was arrested by law enforcement at around 9:30 p.m. that same day.
Here's the home. Police say Sessler also admitted animals, at closed businesses and schools in the middle of night, also setting fires.
Crime scene investigators who examined the Sessler family home described it as a war zone. The house was covered in blood, with large pools staining the floors and splattered on the walls. Furniture was overturned, and broken items were scattered across the rooms, making it look like the house had been destroyed in a violent struggle. Bloodstains marked the path Trey had taken after each incident, allowing investigators to piece together the terrifying sequence of events.
Shooting large animals has talked about setting a few small grass fires. He has taken rifles and shot buildings.
Trey was arrested and charged with the murders of his mother, father, and brother. During his police interview, Trey confessed to the acts, explaining that he had taken the lives of his family members to spare them from feeling ashamed when he planned to carry out a mass attack at his former high school. However, Trey said the reality of the situation hit him too hard, and he ultimately decided to back out of the attack. He admitted that his violent actions were not a one-time occurrence, as he had engaged in violent behavior before, including harming animals and firing his weapons near schools late at night, although he had no prior criminal history before the murders.
Officials say he researched serial killers online and even graded their work. He told investigators.
Further investigation into Trey revealed that he had been strongly influenced by past mass violence incidents, particularly the Columbine High School tragedy in 1999 and the 2007 Virginia Tech massacre. Trey had spent a significant amount of time researching both events and appeared to idolize the perpetrators. Authorities discovered a document on his computer where he had graded and studied the actions of 8 different serial killers. This disturbing glimpse into his mindset showed how deeply Trey had immersed himself in the world of mass violence and murder.
As Trey Sessler stayed here from time to time.
He'd just pull up in his garage and stay however long, a couple of days.
In the days after the murders, Trey reached out to other relatives, offering apologies for his actions. He expressed remorse, but many found it hard to believe the sincerity of his words, given the horrific nature of the crime. The small town of Waller, Texas, was left in shock as the community struggled to understand how such a brutal and senseless crime could occur in their otherwise peaceful neighborhood.
Top 8 serial graded about what action they took, but he also studied all kinds of mass, just the Columbine and other school events.
On August 2nd, 2012, Trey pleaded guilty to all charges against him, including 3 counts of first-degree murder. The judge sentenced him to life in prison without the possibility of parole, a sentence that would keep him behind bars for the rest of his life. Trey remained silent during the hearing, offering no further explanation for his actions. The decision to give him life instead of the death penalty left many residents of Waller feeling disappointed. They had hoped for a harsher punishment, believing that Trey's crimes deserved the ultimate penalty. Jason Wilson is in court to give a victim impact statement after his sister, Misty, lost her life at the hands of her husband, Tristan Laro, who has admitted to the act. Misty was found on the bathroom floor of their apartment, with 5 injuries to her head. As Wilson walks up to the podium, he gives Laro a long, hard stare. He starts speaking to Judge G. Michael Westall, explaining how his sister's demise has deeply affected his life. His voice shakes as he struggles with his emotions. Meanwhile, Laro sits back in his chair, showing no reaction and acting casual. Overcome with grief and anger, Wilson turns to Laro and demands to know why he did it. What happens next is beyond belief. As deputies hurry to hold Wilson back, Laro suddenly makes a move, as if he's about to fight back. A deputy quickly steps in, grabbing Laro from behind and pulling him to the ground. At the same time, other deputies struggle to restrain Wilson, using just as much force. On the floor, Wilson continues to resist more aggressively, while Laro appears to stay still. Let's take another look at how fast everything happened. Wilson is eventually restrained and handcuffed. As deputies help him to his feet, he repeatedly apologizes for his outburst before being escorted out of the courtroom. Although Iron County Attorney Scott Garrett initially mentions plans to charge Wilson with disorderly conduct, no charges are filed. Tristan Laro is sentenced to 15 years to life for Misty's murder. In 2014, Florida State University law professor Dan Markell was murdered in a meticulously planned assassination. The investigation revealed that Catherine Magbanua acted as an intermediary, coordinating the murder-for-hire plot between the Adelson family, Markell's former in-laws, and the hired hitmen Sigfredo Garcia and Luis Rivera. Magbanua was romantically linked to both Charlie Adelson, Markell's former brother-in-law, and Garcia, the father of her children. In May 2022, after a retrial, Magbanua was found guilty of first-degree murder, conspiracy to commit murder, and solicitation to commit murder. On July 29, 2022, Circuit Judge Robert Wheeler sentenced her to life in prison without the possibility of parole for the murder charge, plus 2 additional consecutive 30-year sentences for the conspiracy and solicitation charges.
Okay, and the state's asking that all sentences run consecutive, is that correct?
Yes, Your Honor.
All right, the state's ready to proceed to sentencing in the state of Florida versus Catherine Magbanua, 2016 CF 3036 and 2018 CF 497. Ms. Magbanua is present here in the courtroom along with her counsel. On count 1, which is the count of first-degree murder, you have been found guilty by a jury. You will be adjudicated guilty, and you will be sentenced to life in prison with no eligibility for probation or parole. On count 2, which is the conspiracy to commit murder, you have been found guilty by a jury. You will be adjudicated guilty, and you will be sentenced to a consecutive sentence of 30 years in the Department of Corrections. On count 3, the solicitation to commit murder, you have been found guilty by a jury of that count. You are adjudicated guilty, and you will be sentenced to a consecutive sentence of 30 years in the Department of Corrections. You have credit for time served of 2,119 days. Your court costs are $2,625 and $100 cost of prosecution, and those will be civil judged. You have 30 days to file a notice of appeal, and if you cannot afford counsel, then one would be appointed for you.
During the sentencing, Dan Markell's sister, Shelley Markell, delivered a poignant victim impact statement. She reminisced about their shared childhood and the families they had begun to raise, expressing profound sorrow that her brother would no longer be present for future moments. Relentless and untamed, Victor Rodas, a 17-year-old alleged MS-13 gang member, was convicted in October 2023 for the brutal murder of Raymond Wood, a 16-year-old from Lynchburg, Virginia.
The dragon's head was pulled out of a box and shown to the jury this afternoon. Maddox told the prosecution the blade alone was over 9 inches.
In 2017, Raymond Wood was found in Bedford County with 29 stab wounds, leading to his tragic loss. The investigation revealed that Victor Rodas, along with other gang associates, had abducted and murdered Wood, allegedly as part of gang activity. During the trial, evidence suggested that Rodas played a key role in the crime, which was believed to be an execution-style murder, a tactic commonly used by MS-13 to maintain control and instill fear. The jury found Rodas guilty on multiple charges, including first-degree murder, abduction, and gang participation.
An admitted MS-13 gang member also testified. He talked about his prior gang activity before being arrested. He also talked about the culture and day-to-day activity of being an MS-13 member, what they do and don't, and how to be a part of the gang and how to get out. Testimony continues this afternoon. We will have the latest from the courthouse tonight.
The case brought attention to the growing problem of gang violence in Virginia, particularly the influence of MS-13, a notorious criminal organization with a significant presence both in the U.S. and internationally. Victor Rodas was sentenced to a total of 55 years in prison, with the jury recommending 35 years for first-degree murder, 10 years for abduction, and another 10 years for his involvement in gang activities. The prosecution emphasized the extreme nature of the crime, which involved not only a violent act but also an abduction, highlighting the dangers of gang involvement and its impact on the community. The sentencing was seen as an important step in holding gang members accountable for the harm they caused to both their victims and society.
6 of this year, Maddox went to Long Hill Road. Maddox says as he was returning to his car, something caught his eye.
So I decided instead of walking back through the high grass, I would walk straight through the woods to my car. I walked about 20 yards and looked down because it was a shimmer of light that hit just right, caught my attention. I looked down on the ground and saw a dragon's head, a metal dragon's head on top of the ground.
The dragon's head was pulled out of a box and shown to the jury this afternoon. Maddox told the prosecution the blade alone was over 9 inches. He also said he recognized the knife from an earlier picture showing it in a shadow box hanging on a wall. A co-conspirator who cannot be named says he met with other members of the MS-13 Sailors.
Raymond Wood's family and the local community were left devastated by the loss, and the trial highlighted the ongoing efforts of law enforcement to dismantle MS-13's network in the region. The case also sparked further discussions about the role of gangs in recruiting young people and using violence to settle disputes. As gang-related crimes continue to rise, the conviction of Victor Rodas serves as both a warning and a reminder of the dangers posed by criminal organizations operating within the U.S. Rodas's sentencing is one step toward addressing this serious issue, but it also emphasizes the need for continued prevention and intervention programs aimed at curbing gang violence. On February 14, 2017, 43-year-old Janelle Bohr called 911 in Michigan to report that her husband, 35-year-old Gregory Bohr, had been fatally injured in their home. When authorities arrived, they discovered Gregory unresponsive with a severe injury to his head in the basement. Janelle was located in the garage with an injury to her arm. She informed authorities that the incident occurred following an altercation with Gregory. The couple had been going through a divorce and were estranged, with their 2 children not present on the day of the murder. Janelle claimed that during the argument, Gregory pulled out a weapon and injured her arm before harming himself, prompting her to call the police. However, the scene didn't match her story. The way Gregory's body was positioned and the crime scene details led police to believe Janelle was lying. They quickly ruled Gregory's demise as a homicide rather than a suicide.
I can only hope that where you were going, you get all of the attention you crave and more. Greg was a man to whom family came first. He was my firstborn son and often my helper, both as a child and as a man. He was my son, my friend, my neighbor. By killing my son, you have torn the fabric of my entire family. He was honest, trustworthy, dependable, and kind-hearted. He was too kind to be safe from a monster like you.
I will never forgive you for what you've done. You've shattered our lives, and most importantly, the lives of Greg's children. I only wish I could trade your worthless, selfish, pathetic life for Greg's. You've stolen a good father from his children. You have taken my big brother and one of my best friends. You do not deserve to bear my family's name. You are nothing more than a sick animal that should be put down. No human being deserving of their next breath would do what you have done. I wish you had never met my brother and none of this had ever happened, but it's too late for that. What you have done can't be undone, and it cannot and will not be forgiven. I am disgusted with a sentence of 17 years minimum. I think it is a sad and pathetic punishment for what you have done. I assure you that when the time comes for your first parole hearing, I will be there, likely with your son and many others at my side, arguing for why you should stay for your final 2 years of your sentence. Hopefully you will die in your cell, cold and lonely, before that day comes. I hope you rot.
Forensic tests soon revealed that Gregory Bohr had not harmed himself. In fact, it was Janelle who had injured him before discharging additional rounds into the room. She also injured herself in the arm, likely to make the police believe her version of events. Janelle was arrested and charged with open murder and felony firearm offenses. Further investigation showed that after ending the life of Gregory, Janelle had rearranged the crime scene to support her story. She claimed that Gregory was abusive and violent, but everyone who knew him contradicted her statement. As a result, Janelle eventually pleaded guilty to second-degree murder, which reduced the likelihood of a life sentence. In February 2018, Janelle stood in court while her former in-laws gave victim impact statements. Gregory's mother, Sharon Bohr, addressed Janelle, telling her, "You had no right to kill my son. He did nothing but believe you, take you in, and love you. I can only hope that where you are going, you get all of the attention you crave and more." In December 2019, 25-year-old Marcus Fishburne brutally murdered his roommate's girlfriend, 25-year-old Aisha Levy, in Jacksonville, Florida. Levy's boyfriend returned to their apartment to find blood throughout the residence and a note from Fishburne indicating both he and Levy had passed, with a threat that the boyfriend would be next. Levy's body was discovered wrapped in a plastic storage bin hidden in a closet. Fishburne was apprehended at a Greyhound bus terminal attempting to flee to Indiana. He confessed to attacking Levy as she exited the shower, binding her hands and then stabbing, strangling, and bludgeoning her with a hammer. In February 2024, Fishburne pleaded guilty to first-degree murder and kidnapping. During the penalty phase, a jury recommended the death penalty by a 10-2 vote. On June 13, 2024, a Jacksonville judge sentenced Fishburne to death for his crimes.
Thank you. All right, Mr. Fishburne, I will begin with count 2, the kidnapping charge to which you pled guilty and to which this court will now adjudicate you guilty and sentence you to life in prison with credit for 1,637 days for time already served. The court will assess the mandatory felony court costs of $518 and total public defender fees of $150, and that's $50 for application and $100 for service. And as to count 1 for murder in the first degree, Mr. Fishburne, the court has carefully considered and weighed the proven aggravators and all of the mitigating circumstances. The law requires the court to give great weight to the jury's recommendation that the defendant be sentenced to death, and after assessing the proven aggravating factors and all of the mitigating circumstances, as well as the evidence presented to this court at the Spencer hearing, this court is in agreement with the jury's recommendation. So accordingly, this court finds that death is the appropriate penalty for the defendant, given the highly egregious nature of this crime. So, Mr. Fishburne, you have not only forfeited your right to live among us, but under the laws of the state of Florida, you have forfeited your right to life. The scales of life versus death in the murder of Aisha Levy tilt in favor of death, and therefore, Mr. Fishburne, I will now adjudge you guilty of murder in the first degree and sentence you to death for the murder of Aisha Levy. You are hereby notified that this sentence is subject to automatic review by the Supreme Court of the state of Florida, and counsel will be appointed by separate order to represent you for that purpose. It is also further ordered that you be transported to the Department of Corrections to be securely held on Florida's death row until the sentence can be carried out as provided by law. So, Mr. Fishburne, may God have mercy on your soul. That concludes the sentencing today. Thank you.
During the sentencing, Aisha Levy and her family shared emotional victim impact statements, describing the deep pain and loss they have gone through. Next, we turn to the shocking case of teen offender Ethan Couch, whose defense argued that he was too wealthy to face the consequences of his actions. His controversial sentence left the courtroom in disbelief and sparked intense debate across the country.
crashing into a group of people who were helping 24-year-old Brianna Mitchell, who had broken down on the side of the road. Mitchell, Holly Boyles, her daughter Shelby Boyles, and youth pastor Brian Jennings.
Ethan Couch was born into an upper-middle-class family in Burleson, Texas. At 13, he began attending Anderson Private School, a prestigious institution, but was soon removed after the principal raised concerns about his behavior. His parents, Fred and Tanya, transferred him to a co-op in Watauga, where things seemed to improve. By age 15, Ethan enrolled in community college and appeared to be on a promising path. However, his legal troubles were far from over. At 15, Ethan was found in a parked pickup truck with an unconscious 14-year-old girl. He was charged with minor consumption and possession of alcohol, pleading guilty and receiving probation, an alcohol awareness course, and community service. Unfortunately, his troubles escalated further. On June 15, 2013, Ethan, along with a group of friends, drove his father's 2012 red Ford pickup truck with 7 passengers inside after stealing 2 cases of beer from Walmart. Speeding down the road, he crashed into Brianna Mitchell's stalled SUV, causing Brianna, Holly, Shelby, and Brian Jennings to lose their lives. Sergio Molina, a passenger in Ethan's vehicle, survived but was paralyzed from the neck down. Ethan's blood alcohol level was 0.24%, 3 times over the legal limit, and he also tested positive for marijuana and diazepam. He was arrested and charged with 4 counts of intoxication manslaughter and 2 counts of intoxication assault, though he pleaded not guilty. As the case unfolded, it was revealed that Ethan's parents, Fred and Tanya, had criminal backgrounds. Fred had been charged with evading arrest, theft by check, and assaulting Tanya. Tanya had been fined and given community service for reckless driving in 2013. These revelations raised concerns about the family's disregard for the law. The defense took a controversial turn when psychologist G. Dick Miller testified that Ethan suffered from affluenza, claiming that Ethan couldn't connect his actions to their consequences due to being raised in a privileged environment where wealth and power distorted his moral compass. This claim gained international attention, with the defense arguing that Ethan's wealth shielded him from understanding the consequences of his actions.
Upbringing affluenza defense and received 10 years probation.
Many people found the affluenza defense ridiculous and offensive. Critics said it suggested that wealthy people were above the law and didn't have to take responsibility for their actions. This sparked debates about privilege and the role of parents in raising their children. As Ethan Couch faced consequences, his family's reactions were mixed. Tanya Couch showed regret for her son's actions, but defended using the affluenza defense. Fred Couch, however, didn't show any remorse and blamed the media for what happened to his son. These reactions caused even more public anger and debate about the fairness of Ethan's sentence. Some felt his punishment wasn't enough, while others thought it was necessary to hold him accountable. Ethan was sentenced to attend an expensive rehab center, costing around $500,000 a year. In addition, he was placed on probation for 10 years with several restrictions, including wearing an ankle monitor, submitting to substance tests, and having a 9 p.m. curfew. He was also required to install a special device in his car that wouldn't let him drive if he was intoxicated. Eric Bowe, Holly's husband and Shelby's father, spoke out in 2014, saying that he thought Ethan's sentence was too light. He believed that if Ethan hadn't had the money for a high-quality defense, the outcome might have been different. This sparked more controversy, with people questioning if the punishment was fair. Meanwhile, 6 civil lawsuits were filed by the victims and survivors' families against Ethan and his family, seeking justice and compensation for their pain. However, all the lawsuits were settled out of court, allowing everyone to move forward. Despite being in rehab and on probation, Ethan Couch continued to defy the legal system. In December 2015, police were alerted to a tweet claiming that Ethan was playing beer pong at a party and drinking alcohol, which was a clear violation of his probation. This prompted an investigation and led to a warrant for his arrest. However, Ethan managed to avoid capture, and his probation officer couldn't get in touch with his mother, Tanya. The search for Ethan intensified, with U.S. Marshals and the FBI joining in. By the end of December, Ethan and Tanya were found in Mexico and brought back to the U.S. Ethan was taken into custody and faced further consequences. On April 13, 2016, District Judge Wayne Salvant sentenced him to 4 consecutive terms of 8 days, which extended his probation. Just when it seemed like Ethan might have learned his lesson, he ran into trouble again. In January 2017, he was accused of violating his probation after testing positive for THC. To the surprise of many, Ethan was was released just one day after it was determined that the positive test result could have been caused by either illegal substances or CBD oil. The leniency shown toward him sparked more outrage, with critics questioning whether the legal system was handling repeat offenders properly. Ethan Couch's reckless actions and the controversial affluenza defense continued to upset many people. Bo Dukes, one of the men connected to the disappearance and demise of Tara Grinstead, was sentenced to the maximum penalty of 25 years in prison in Wilcox County Superior Court. Following a 4-day trial, Dukes was convicted of 4 charges, including lying to the Georgia Bureau of Investigation, GBI, hindering the apprehension of a criminal, and concealing Grinstead's demise. The case revolved around Dukes' involvement in burning Grinstead's body to destroy evidence, which left her family and community devastated. Tara's stepmother, Connie Grinstead, spoke during the sentencing, recounting the emotional toll and condemning Dukes' actions. Dukes admitted his actions were calloused and cruel, apologized to Tara's family and others affected, and expressed remorse. Despite his defense citing his prior military service and cooperation with investigators in 2017, the judge highlighted Dukes' previous crimes, including stealing $150,000 from the Army and his repeated failure to come forward about the case for over a decade.
2017 CRW 038. The court's going to sentence you on count 1 to a period of 5 years to serve in the state penitentiary. On count 2, the court's going to sentence you to 5 years to serve in the state penitentiary consecutive to count 1. And on count 3, the court's going to sentence you to 5 years consecutive to count 2 to serve in the state penitentiary. And on count 4, the court's going to sentence you to 10 years consecutive to the sentence in count 3 to serve in the state penitentiary. Now, your sentence, you can appeal this conviction by filing an appeal or motion for new trial within 30 days from the date of this sentence. Do you understand that? Mr. Fox, you can assist him with that.
Yes, sir.
You also have the right to file for habeas corpus relief within 4 years from the date of this sentence. You understand that?
We do, Your Honor.
All right, that's the sentence of the court.
Your Honor, the record just reflected our objection to the non-merger of counsel.
Yes, sir. Your objection is noted. Yes, sir. Okay. All right.
Dukes still faces additional charges in Ben Hill County related to burning Grinstead's body, and in Houston County for allegedly sexually assaulting 2 women. Meanwhile, Ryan Duke, another suspect in the case, is awaiting trial for Grinstead's murder. In January 2010, 16-year-old Daniel Kovarbese fatally stabbed 55-year-old Dwayne Hurley in North Ridgeville, Ohio. Kovarbese alleged that Hurley had been abusing him for over 3 years, following a typical grooming process that began when Kovarbese was 12. On the day of the incident, Kovarbese claimed he acted in self-defense after Hurley attempted to initiate sexual contact. In April 2010, Lorain County Common Pleas Judge James Burge found Kovarbese guilty of voluntary manslaughter and aggravated assault.
The Daniel's story didn't change, it varied. It went from self-defense to no defense at all. But I don't find that change in the account is due to his calculating personality or intellect. The psychological report, mental status report that was conducted before this matter was bound over to the adult system indicated that, although not mentally ill, Daniel was very low functioning at the time this offense was committed. I hope that the conclusion is that the low functioning was due to a lack of interest rather than a lack of intellect. Or it will be the judgment of law and sentence of the court that this defendant serve a community control sanction with a term of 5 years, which will expire on August 12, 2015. Before completing this community control sanction, the defendant will receive a high school education and a driver's license. He will be under intensive supervision for a period of 5 years. He will remain incarcerated until admitted to a program of rehabilitation selected by the court.
One of these conditions required that he remain in custody until a suitable juvenile rehabilitation facility could be found. Due to the violent nature of the crime, placement in such a facility proved challenging. Consequently, Kovar Basic spent approximately 16 months in the Lorain County Jail before being released under house arrest in May 2011, pending placement in a treatment program. The case drew significant media attention, highlighting issues of abuse, self-defense, and the complexities of sentencing in cases involving juvenile offenders. Kovar Basic and his family appeared on The Oprah Winfrey Show to discuss the abuse and its aftermath, aiming to raise awareness about the grooming process and the importance of reporting sexual abuse. On February 10, 2018, officers Eric Joring and Anthony Tony Morelli responded to a domestic violence call in Westerville, Columbus, Ohio. A woman named Candace had called 911 and hung up. When the officers arrived, they learned that Candace's husband, Quentin Smith, had punched and choked her, accusing her of cheating. He choked her until she passed out, and when she regained consciousness, she called 911 but didn't speak because she feared he would hear her talking to the police. When the officers arrived, Smith became furious that Candace had called for help and taken the weapons he had hidden in the couch. A struggle broke out between Smith and the officers, during which he injured both Joring and Morelli. He struck Morelli in the chest, causing critical damage to his heart and lungs, and injured Joring 3 times in the arms and head. Joring succumbed to his injuries immediately, while Morelli passed away later that day in the hospital. Smith was also injured 5 times, but survived. Quentin Smith was charged with 2 counts of aggravated murder and illegal possession of a firearm, as he was not allowed to have a weapon at the time. His trial lasted 2 years and gained national attention, with many people outraged by the brutal murders of the officers. Both former President Donald Trump and Governor John Kasich spoke out about the violence during the trial. One of the witnesses, fellow officer Timothy Ray, was visibly upset and struggled to hold back tears while testifying.
As I was going past the first department, another shot.
Another police officer, Stacy Pentecost, was unable to hold back her tears as she gave her testimony in court.
Officer Morelli was laying on the floor, holding himself up by his elbow.
It was an emotional time for many in the courtroom. The families of Morelli and Joring were given the chance to deliver victim impact statements, marking the first time families were allowed to do so during the trial of a capital offense. Both the prosecutor and the defense lawyer worked hard to present their cases and arguments before the judge and the jury. In the end, it all came down to these 2 parties, as they were the only ones who could determine the outcome of the case.
The jury being deadlocked and unable to agree on whether the aggravating circumstances outweigh the mitigating factors beyond a reasonable doubt, hereby unanimously return the following life sentence on count 1.
Quentin showed no emotion as the jury read his sentence. Although he was eligible for the death penalty, he was sentenced to 2 consecutive life sentences without the possibility of parole. Regardless of the punishment, this brought an end to the 2-year-long trial. In honor of the victims, highways were dedicated to their memory. On May 27, 2011, 26-year-old nursing student Michelle Huang T. Lee was reported missing after her white Honda SUV was found, parked with bloodstains inside on Ponderosa Court, near the Kaiser Permanente Medical Center in Hayward, California, where she both studied and worked. Despite her family putting up billboards and offering a reward for information, it wasn't until September 17th that search teams found decomposed human remains in a remote canyon area. The remains were identified as Michelle's. 27-year-old Giselle DeWag Esteban, a former high school friend of Michelle's, quickly became the main suspect after security footage showed her near the crime scene. As investigators looked deeper into the case, they began to uncover a clearer motive for Giselle's possible involvement in Michelle's murder.
At one point, you and Michelle were close friends, is that right?
I considered her my sister.
And then, what happened?
She made a mistake. Scott made a mistake.
Esteban and Michelle had been high school classmates and friends, but their relationship soured after Michelle briefly dated Scott Marasigan, Esteban's ex-boyfriend, who was also the father of their 6-year-old daughter. Esteban was upset by Marasigan's continued closeness with Michelle and would often send him threatening messages to stay away from her. This behavior led Marasigan to file for a restraining order against Esteban, which only fueled her anger, later targeting Michelle. Evidence showed that Esteban had researched ways to commit murder and had been tracking Michelle's movements and schedule. This allowed her to successfully ambush Michelle at her school, take Michelle's car, and drive to a remote area where Michelle's body was eventually found. Hair from Esteban was found inside Michelle's car, and cell phone records further confirmed Esteban's involvement in the crime. On September 7, 2011, just days before Michelle's body was discovered, Esteban was arrested and charged with murder. At her trial in October 2012, she pleaded not guilty, but the evidence against her was overwhelming. The jury convicted her of first-degree murder. On December 10, 2012, Esteban was sentenced to life in prison without the possibility of parole for 25 years. During her sentencing, Esteban showed no emotion, remaining as indifferent as she had been when the jury delivered its guilty verdict. She seemed to accept the outcome and even told her attorney, "Let it go," implying she no longer felt the need to defend herself.
The judge says he has never seen a hint of remorse from Esteban and hopes someday she will feel this.
We always felt, sitting in trial, that she felt no remorse. Just stared directly at our family with a blank stare, and so it was good that he pointed that out.
Struggling to control her emotions, Christine D., Michelle's cousin, addressed the judge. She told the court that while Esteban may have taken Michelle's life, she could never take away Michelle's legacy or the light she brought into the world. At the time of the murder, Esteban was pregnant and gave birth to a child while in custody, just a few months before her hearing. The child was later placed in the care of Esteban's father. Esteban is set to remain in prison at least until 2037. In a tragic and unusual case, an 18-year-old Macon man, Ori Mathis, was found guilty of murder and burglary, stemming from a 2017 incident where a burglary went awry, resulting in the demise of his uncle, James Robert Young Jr. Mathis and Young broke into the home of a 5th-grade teacher, assuming it was unoccupied. When the teacher confronted them, Mathis, armed with a .40 caliber Glock pistol, attempted to fire at her, but accidentally struck Young instead. Mathis, who was 16 at the time of the crime, faced trial after declining a plea deal offering a 30-year sentence with eligibility for parole.
It makes it exponentially worse, in my view, that when the person who owned those things found somebody invading the sanctity of their home, you tried to kill her. For no reason other than that she just had the temerity to be in her own house, minding her own business, while you were there trying to steal from her. Of all people, a school teacher. Somebody who spent a grown-up life helping kids. And you tried to kill us.
Despite claims by his parents that he was asleep during the incident, evidence and witness testimony placed Mathis at the scene. After a brief deliberation, the jury convicted him of both murder and burglary. During sentencing, Judge Howard Z. Sims harshly criticized Mathis for attempting to rob someone who had worked hard for their belongings, emphasizing the cruelty of attempting to harm the victim simply because she was present in her home.
You're lucky in one respect, and that's this, that because you were 16, the law will not allow me to sentence you to life in the penitentiary without the possibility of parole, because I would do it in a second. But I can't. So I'm going to do the next best thing. On count 2, life in the penitentiary. And on count 4, 20 years in the penitentiary consecutive to that. Anything else, Ms. Old? Mr. Ryan.
Due to Mathis's age at the time of the crime, the judge could not impose a life sentence without parole, but sentenced him to at least 50 years in prison. Mathis's mother reacted with anguish as the sentence was handed down. On May 27, 2012, Candace Marie Rice, a 29-year-old resident of Macon, Georgia, was fatally stabbed. Her boyfriend, Bobby Lee Fordham Jr., then 31, was subsequently arrested and charged with her murder. In 2013, Fordham Jr. was convicted and sentenced to life imprisonment without the possibility of parole for the crime.
The case of the state of Georgia versus Bobby Lee Fordham, indictment number 12 CR 68714. On the charge of malice murder and count 1 of the indictment, we, the jury, find the defendant guilty. As to count 2 of the indictment on the charge of felony murder, we, the jury, find the defendant guilty. And as to count 3, charge of theft by taking, we, the jury, find the defendant guilty. And it's dated today and signed by Mr. Brown's court person. Mr. Fordham, you are the poster child for domestic violence cases. You understand that? You've been hitting this woman, I know, at least since 2012. And you did a pretty good job of thrashing her around that night when I saw from all types of things. And this business about anger management issues that you told the police down there, anger management issues, translation, I'm just plain mean. That's what that means, really. All the therapy, all the counseling, all the drugs, and all the good intentions in the world can't fix meaning. Meaning's blind. There really are only 2 ways to deal with somebody who's that mean, and you are. One is to put them down, like you would a rabid dog. The other is to put them away somewhere where they don't get the chance to hurt anybody again ever. The former is not on the table, but the latter, I got that. The Fordham, I sentence you after the conviction of malice murder in this case to life in the penitentiary without the possibility of parole. On count 2, I sentence you to 10 years in the penitentiary reserved consecutive to the sentence in count 1. Any questions about that?
No, Your Honor.
Any questions, Mr. Freeman?
No, Your Honor.
Candace Rice was remembered in her obituary as a mother of 3 children, Darius, Marquise, and April. She was also survived by her father, Gregory Rice, and 2 brothers, Anthony and Gregory Rice Jr. Adam Matos was convicted of the 2014 murders of his ex-girlfriend Megan Brown, her parents Greg and Margaret Brown, and her new boyfriend Nick Leonard in Pasco County, Florida. Matos and Megan Brown shared a 4-year-old son, who was present in the home during the incident and remained there with Matos for several days afterward. During the trial, Matos admitted to the events, but claimed self-defense and paranoia led to his actions. The jury found him guilty on 4 counts of premeditated first-degree murder. In the sentencing phase, the jury did not unanimously agree on the death penalty, with 1 juror voting against it for 3 of the victims and 2 jurors voting against it for the 4th. As a result, Matos was sentenced to life in prison without the possibility of parole.
And based on the decision of the jury, I sentence you in count 1 and count 4 to life in prison without the possibility of parole. In counts 2 and 3, I sentence you to life without the possibility of parole. However, that's with a firearm, discharge, include charging, which means hopefully that no matter what happens with the legislature, no matter what we decide on life or death in your case, you will never, ever be released from prison. Can you afford to hire an attorney for your appeal?
No, Your Honor.
All right, so at this point, I will appoint the public defender to represent you for appeal. State, is there any costs associated that you're asking me to impose?
Judge Mary Hansel, who presided over the case, described Matos's actions as selfish.
This was the most selfish, self-centered, evil thing that I've ever heard. That you took the stand and you said that you did all of this for your son is ridiculous. Your son was in the house when this occurred. He was either in the room or within 65, 70 feet of when you, his mother, his grandfather, and then waited 5 hours by your own admission to walk downstairs and beat his grandmother to In those 5 hours, you must have sat in that house with your son. He was there. It's 6 o'clock in the evening. He's not asleep. He's not locked in his room. You're sitting there with your son, with his mother, his grandfather, and a man who gave his life for those people.
During the sentencing phase of Adam Matos's trial, family members of the victims delivered poignant impact statements expressing their grief and the profound effects of the murders on their lives. Richard Brown, the younger brother of Gregory Brown, criticized Matos for his dishonesty during the trial, stating, "Matos continued to lie when he took the stand." In April 2013, Brandon Davis, then 33, was arrested for the murder of 26-year-old Chastity Lester, the mother of his child, in Macon, Georgia. The incident reportedly stemmed from an argument over child support, and at the time of her demise, Lester was pregnant with another man's child. Davis was indicted by a Bibb County grand jury on charges of malice murder and felony murder predicated on aggravated assault. In March 2016, he entered a negotiated plea agreement pleading guilty to felony murder while the malice murder charge was dismissed. Consequently, Davis received a life sentence.
Murder scene, the DNA from the victim's car showing that blood at the residence at Flamingo Drive was the blood of the victims, Miss Lester. We had the blood in the car that was also blood of Miss Lester. And we were also in possession of the hammer with DNA on it with Miss Lester that was used as a murder weapon, along with a knife that was located with it that we believe may have been used in murder.
Approximately 2 weeks after his sentencing, Davis, through his plea counsel, filed a motion to withdraw his guilty plea, alleging manifest injustice and claiming ineffective assistance of counsel. He contended that his attorney had insufficient time to prepare for the case and that his plea was not entered knowingly and voluntarily. The trial court denied this motion without appointing new counsel or receiving evidence on the claim. Davis appealed, and in 2017, the Supreme Court of Georgia reversed the trial court's decision, remanding the case for a hearing on Davis's ineffectiveness claim with new counsel. On remand, the trial court again denied Davis's motion to withdraw his guilty plea. Davis's subsequent appeal was dismissed as untimely, but he was later granted an out-of-time appeal. In 2019, the Supreme Court of Georgia affirmed the trial court's decision, concluding that Davis failed to demonstrate that his counsel's performance was deficient, or that he was prejudiced by any alleged deficiency. As a result, Brandon Davis remains incarcerated, serving a life sentence for the murder of Chastity Lester. In November 2018, Susan Kubicek of Portage, Michigan, was sentenced to 60 months to 15 years in prison for involuntary manslaughter in the demise of her 87-year-old mother, Dorothy Dot Allen. The case drew significant attention due to the circumstances surrounding Allen's demise and Kubicek's actions. According to court testimony, Kubicek administered up to 80 times the prescribed amount of morphine to her mother, leading to Allen's demise on May 5, 2017, when questioned by police, Kubicek reportedly stated, "It's her time to go anyways." This statement, along with the excessive dosage, played a crucial role in the charges brought against her.
The Bible says we have to love our family, but I don't have to be around my sister Sue anymore. You have put a scar on my heart and my family's heart. You have lied to family and friends over and over. Can I forgive you? I don't know. Can God forgive you for what you've done? I don't know. As you do your time given, think about what you've done and be ready to suffer the consequences. And that's all I have to say.
Thank you, Mr. Salem.
During the trial, the prosecution argued that Kubicek's actions were reckless and directly led to her mother's demise.
It's a terrible situation, obviously, and it's really created some emotional trauma to the family as a result of what's happened here. We recognize that
the defendant does have some issues herself. And she was placed in a position of having to render hospice, if you will, to her mother. And she was challenged by that, and obviously she took the wrong path in administering the medication to her mother.
The defense, however, contended that Kubitschek was acting out of compassion, attempting to alleviate her mother's suffering.
I only did what I was instructed to do by a nurse. And God knows my heart, and God knows the truth. That's it.
When I sentenced you, Ms. Kubitschek, I balanced the principles of punishment, rehabilitation, protection of society, as well as deterrence. I consider the positive and the negative things you bring before the court. You were entrusted with the care of your ailing mother, and I can certainly understand the frustration that you were in and maybe some realization of your mother's condition. However, what you did was inexcusable. According to the investigation, your mother, Ms. Allen, was supposed to get 10 milligrams of morphine every 15 minutes to an hour as needed, and you put together 10 milliliters every 15 minutes, which is, according to the assessment here, 80 times more than what she was prescribed. You were, for a period of time, responsible for her care. A vulnerable person who could not take care of herself needed somebody to care for her. And you disregarded that responsibility and took matters into your own hands.
Ultimately, the jury found Kubitschek guilty of involuntary manslaughter, leading to her sentencing in November 2018. Former Bibb County Sheriff's Deputy Jeffrey Brian Prestridge, 35, was sentenced to 20 years with 10 years to be served in prison after pleading guilty to multiple charges of physical abuse against former girlfriends and 2 boys. Superior Court Judge Howard Sims, who presided over the case, referred to Prestridge as a bully with a badge during the sentencing. Prestridge's arrest in February 2016 followed an incident on October 30th, 2015, involving a female with whom he was in a relationship. He was charged with aggravated assault, aggravated battery, and false imprisonment.
I stand before you today as a broken man. There's no witnesses so dreadful, no accuser so terrible in my own conscience. Over the past 10 years of my life, this has never been so true. As I sit in my cell 23 hours a day, my conscience has been tearing at me relentlessly. To my victims and their families, all for my deepest apology, as I hope one day they'll forgive me. To the citizens of Bibb County and to the Sheriff's Department who entrusted in me, I offer my sincerest apology. I also ask that the citizens of Bibb County not to judge the other officers based upon my actions. Sorry. My only goal is to get the help I need to be able to control my anger issues and to one day make amends for the pain I've caused. Your Honor, I stand at you for a fair and just sentence. Please, I place myself at the mercy of the court.
Mr. President?
Yes, sir.
That was very eloquent.
Yes, sir.
But you wouldn't have had to say it, but for your own action. You know that, and I know that.
Yes, sir.
These ladies, these women, they're not lying. They never were. You know that, and I know that. You were supposed to be the guy that got between them and somebody like you. You weren't supposed to be that guy. You weren't supposed to be the one hitting, choking, kicking, and threatening these women. You swore that you wouldn't do that. And I think that the people in this community know the sheriff's department well enough to know that they're not like you. And that's why I said there was a dark part of your personality. There was darkness, I believe is the exact word. That's right. And that darkness is deep. And it's dangerous. The long and short of it, Mr. Pressure, is Ms. Alford's right. You're a bully. You were a bully with a bat. But I suspect you're about to find out more about bullies.
Subsequent investigations revealed a pattern of abusive behavior. A grand jury indicted Priestridge on 16 charges, including aggravated assault, false imprisonment, terroristic threats, and child cruelty, involving 5 different women and 3 children. The indictment detailed incidents where Priestridge choked, struck, kicked, and threatened his victims, including pushing a woman's face into a glass window and threatening to murder her. Priestridge was hired by the former Macon Police Department in 2013 and became a Bibb County deputy after the police department and sheriff's office merged in 2014. He was terminated from his position following his arrest in February 2016. In Lorain, Ohio, 36-year-old John Donnie was sentenced to 6 months in jail after being convicted of animal cruelty for hanging his 130-pound mastiff, Memphis. Donnie pleaded no contest to charges of injuring animals and cruelty to companion animals.
Does the state wish to be heard before it pronounced?
Your Honor, I happened to see with some pictures that Officer Grose's investigation showed me, and I wish I had never seen those pictures because I'll probably always remember them the rest of my life. I can't see of a reason not to give him the maximum sentence, Your Honor.
I'd also entertain a motion to amend the charge to the revised code.
Yes, Your Honor, I would move to
The analogous section of the Ohio revised
Yes, Your Honor.
That motion would be granted. Mr. Thompson, anything you'd like to say before I pronounce that?
Just briefly, Your Honor, thank you, and may it please the court, Your Honor. I was able to view the pre-sentence investigation in this case. I do understand that he does have somewhat of a criminal history, Your Honor. I know that you've seen it as well. I understand that this is the kind of case that garners a lot of attention. Your Honor, I know that my client wishes to address the court personally and express his regret. I do believe that both of these counts would be allied, Your Honor, so I believe that the maximum sentence would be 6 months. I know he has a little bit of credit. My suggestion, Your Honor, would be maybe to suspend at least some of the time, and maybe so that maybe the court would then have a tool to use to maybe impose some directives upon my client to make sure that he doesn't do anything like this in the future, and then way you can have that time being reset in case he doesn't comply, Your Honor. Although I do understand that this type of crime is very difficult for the court and for the public.
Lorain Municipal Court Judge Thomas Elwell delivered the sentence, expressing disbelief at the cruelty displayed toward the innocent dog.
Mr. Donnie, anything you'd like to say?
I'm very sorry, and I regret what I have done. I'm sorry on behalf of the courts and on behalf of the whole United States. I'm sorry. I won't do it no more.
Mr. Donnie, this is a very troubling case. Very troubling. I find it just hard to understand how a person could treat a living, breathing creature, a defenseless creature, so with such cruelty. It just boggles my mind. I don't understand what would go through a person's mind before they would take that type of action.
Felix Lopez.
It's very disturbing. And you also have a criminal history that involves offenses of violence. So I really have no choice, really, in my view. And that is to impose the maximum sentence in the case. So it will be the judgment and law and sentence of this court that you be sentenced to 250 in costs and 180 days in the Lorraine County Correctional Facility on count 1. Count 2 will be 90 days in jail, but you're correct, Mr. Thomason, they're allied offenses, so that will be concurrent to count 1.
Prosecutor Jeffrey Sabo had urged the court to impose the maximum penalty for the crime. In November 2022, 17-year-old Yassine Thomas Johnson was fatally injured during a botched robbery in Plymouth, Minnesota. Johnson had arranged to purchase a pair of high-end Balenciaga sneakers from two individuals, Augustus M. Sirleaf and Hans K. Madave. During the transaction, Sirleaf attempted to reclaim the shoes after receiving payment. When Johnson resisted, Sirleaf drew a weapon and fired at him multiple times, resulting in Johnson's demise at the scene. Sirleaf, 20, was charged with 2 counts of second-degree murder. In November 2023, he pleaded guilty to 1 count in exchange for a 23-year prison sentence with credit for time served. He was formally sentenced on January 2, 2024. Madave, also 20, faced similar charges and accepted a plea deal in November 2023.
All right, Augustus Matthew Sirleaf, having pled guilty to murder in the second degree in violation of Minnesota Statute 609.19, subdivision 1, close paren 1, I hereby convict you of that offense and sentence you to the Commissioner of Corrections for a period of 276 months. Against that sentence, I will give you credit for the 411 days that you have already served. I order that you be restricted from the possession of firearms, waive all fines, fees, and surcharges, and order that you pay restitution in the amount of $8,500. And I'll order that you be taken into custody and remanded to the Commissioner of Corrections at this time. Good luck to you, sir.
His sentencing was scheduled for January 10, 2024, with an anticipated prison term ranging from 12.5 to 15 years. In November 2023, Milwaukee rapper Frank Mosley, known as Lil Frank, was involved in a fatal hit-and-run incident that resulted in the loss of 32-year-old Erin Mogensen and her unborn child. Mosley was driving a stolen BMW at speeds up to 116 miles per hour when he collided with Mogensen's vehicle near 100th and Capitol Drive in Milwaukee. After the crash, Mosley fled the scene on foot.
To the jury, we did not mislead the jury in any way. We wanted, Frank Mosley specifically, wanted them to see that it was an accident. He pressed the brakes as hard as he could, we heard testimony. It broke the BMW system, how hard he pressed those brakes. He swerved around cars. And ultimately, he hit the victim here. As I said before, and I'll say again, she did nothing wrong. She was doing nothing wrong. This is 100% Frank Mosley's fault. But it's an accident, a tragic accident. I can listen to comments about myself, about defense's theories, but to paint Frank Mosley as a monster, as a person who did not care, is highly incorrect. He did care. He cared so much that he wrote letters to the family, to the victim, because that's what he wears every day as he's sitting in that cell. Judge, I'll read what Mr. Frank said to the PSI writer. I take responsibility for what happened that caused her death and her unborn child. If I could, I would change places with her. I don't know her, but she didn't deserve this, and there's a special place in heaven for her.
In September 2024, Mosley was convicted on multiple charges, including first-degree reckless homicide, first-degree reckless homicide of an unborn child, hit and run involving death, and eluding an officer.
We have grown men, 30, 40 years old, who fight, cheat, lie and steal to get a favorable sentence. Mr. Mosley didn't do that. We have those same men who never accept what's coming to them. Mr. Mosley is different. I submitted a PSI, or I submitted my sentencing memorandum to the court. We know he graduated, but we also know that he is what I would call a very talented music artist. This case has never been, let's say, low stakes. Let's say everyone has known about this case since it started. It's been a very big deal. There are communities across Wisconsin listening to this court, from the victim side and from the defense's side. After this trial, Running Rebels asked me to speak to the children there. And their question was, what do we do in the situation? I told them to just stop. Stop. If you are in a car, you have drugs in your pocket, just stop. You have license plates that have issues, or this car's not yours, just stop. Just stop, because the court will understand and will respect you for just stopping. You did not make a situation worse. And I believe that a message does need to be sent. But what should that message be? If you make a mistake and we catch you, we're going to send you away for 40 years? Is that the message we want to give them? I don't think so. I think we want this to stop. I want it to stop. How do we get that? We have to reach the youth. And 40 years is unfathomable to a 20-year-old, unfathomable to a 17-year-old, 15-year-old. They think their life is over when it's really not. Sit there, stay calm, and let this process play out, because you will be treated fairly. The courts will hear you. But if you run and you cause this travesty, the death of a very innocent young lady, you're going to have worse consequences. So, Judge, I'm asking for a sentence that penalizes and punishes for Mosley, for sure, but one that also allows him to live more life, as I believe that would be consistent. And I can continue on saying, stop. It will only get worse if you run. Your life will not be over. We will deal with it on the back end. Thank you.
He was subsequently sentenced to 40 years in prison, followed by 10 years of extended supervision. In January 2011, 38-year-old Kimberly McKenzie of Centerville, Georgia, was tragically carjacked, robbed, and fatally injured. The perpetrators, Alexandria Renee Scott and Justin Terrell Grable, forced their way into McKenzie's vehicle near the intersection of Camellia Circle and Ignaco Drive in Warner Robins. They then drove her into a pecan orchard in South Bibb County, where McKenzie was injured in the leg. The bullet severed her femoral artery, leading to her demise from blood loss. In May 2013, Grable pleaded guilty but mentally disabled to his role in the crime and was sentenced to life in prison. He agreed to testify against Scott, who was identified as the individual who fired the weapon. On March 27, 2014, Alexandria Scott pleaded guilty to murder and armed robbery charges in connection with McKenzie's demise. During the sentencing hearing, McKenzie's mother and sister delivered emotional statements, expressing their profound grief and the devastating impact of the loss on their family.
My name is Betsy McKenzie. I'm the mother of Kimberly McKenzie. First I'd like to say is her name is Kimberly Faye McKenzie. Always will be. This loss to me and my family, her son, has taken such an impact that it's a day-to-day struggle. Possibility of parole, crying, I'm very sympathetic because I am a God-fearing woman. But my daughter's not coming back. It weighed no weight here today for me and my family. And I just want you to take that under consideration. Please take it under consideration. Her name is Kimberly Faye McKenzie. Kim's sister, Miss Marshall. And we were only 2 years apart. So we're like, just my best buddy in the world. I just wanted to know that I call you out. Alexander Scott, I want you to know that the family, relatives, and friends of Kim believe she didn't die. Her spirit lives on. We loved her yesterday, today, and every day. I don't know what you believe in, but there is a greater power. And today's judgment doesn't count. I have lived and I will have joy knowing the final judgment will count.
Judge Howard Sims sentenced Scott to life in prison with the possibility of parole after 30 years for the murder charge, and an additional 10-year sentence for the armed robbery charge to be served consecutively. This means Scott will be eligible for parole after serving 40 years. On November 27, 2010, in Elyria, Ohio, 21-year-old Mark Ralich was driving under the influence of alcohol and drugs when he collided with a vehicle driven by 18-year-old Andrew AJ Vincent. Vincent was returning home after attending a Lake Erie Monsters hockey game with friends. The crash resulted in Vincent's demise and caused serious injuries to his passengers, Pat D'Souza and Mitch Johnson. In 2012, Ralich pleaded guilty to aggravated vehicular homicide, vehicular assault, and DUI charges. He was sentenced to 7 years in prison for the crash that claimed the life of Vincent. During his sentencing hearing, Mark Ralich spoke on his own behalf, expressing remorse for his actions.
I had something that I've written down that I was going to say. So, after hearing what everybody said, I just want to say that when I walked into the courtroom, my intention was not to laugh and stare at her, try to make her feel any worse. I feel terrible. I wish I could go back, honestly, and switch places. I know everybody in this room is going to have to live with this for the rest of their life. As well as I am. My intention was never to go out and purposely make me hungry or hurt anybody. It wasn't in the right state of mind. You know, I'm truly sorry. Thank you. Thank you for mercy.
Following his release, Ralich was arrested again on October 13, 2022, by the Lorain County Sheriff's Office for operating a vehicle under the influence, OVI. This arrest raised concerns, given his prior conviction for a fatal DUI incident. The tragic loss of AJ Vincent deeply affected the Elyria community. In his memory, the Elyria Youth Hockey Organization established the AAJ Vincent Memorial Alumni Hockey Game, an annual event that raises funds for a scholarship to assist families with the costs of playing ice hockey. In March 2018, Anaya Day Garrett tragically passed away in Euclid, Ohio, due to severe abuse and neglect inflicted by her mother, Sierra Day, and Day's boyfriend, Deontay Lewis. Anaya was found unresponsive with visible injuries, including burn marks and bruises, and was pronounced dead at the hospital. The Cuyahoga County medical examiner determined that she suffered a stroke caused by blunt force trauma to the head and was emaciated and malnourished at the time of her demise. In March 2019, following a trial, both Day, 24, and Lewis, 27, were convicted on multiple charges, including aggravated murder, felonious assault, permitting child abuse, endangering children, and tampering with evidence. Subsequently, Sierra Day was sentenced to life in prison without the possibility of parole, while Deontay Lewis received a life sentence with the possibility of parole after 20 years.
99A and B, State of Ohio versus Sierra Day and Deontay Lewis. Defendants are in court with counsel. Defendant Day with Thomas Shaughnessy, defendant Lewis with Nicole Longino. Present from the state of Ohio is Anna Faralia, Aquella Jordan, and Sean Kilbane. Ladies and gentlemen, have you reached a verdict in this case?
We have, Your Honor.
If you could give the verdict forms to my bailiff, please. Count 1, aggravated murder. We, the jury in this case, being duly impaneled sworn, do find the defendant Sierra Day guilty of aggravated murder in violation of Revised Code 2903.01C of the Ohio Revised Code as charged in count 1 of the indictment, signed by all 12 jurors. Likewise, count 2, murder, guilty, signed by all 12 jurors. The further finding with respect to count 2 is guilty of felonious assault, permitting child abuse, endangering children as to the offense of violence under the murder B of count 2, signed by all 12 jurors. Count 3, guilty of felonious assault, signed by all 12 jurors. Count 5, endangering children, guilty, signed by all 12 jurors. Further finding that the defendant did cause serious physical harm to Anaya Day, signed by all 12 jurors. Count 6, endangering children, guilty, signed by all 12 jurors. Further finding the defendant did cause serious physical harm to Anaya Day, signed by all 12 jurors. Count 8, tampering with evidence, guilty, signed by all 12 jurors. Count 7 as well, guilty of endangering children, signed by all 12 jurors. The further finding with respect to count 7, the defendant did cause serious physical harm to Anaya Day. With respect to defendant Lewis, count 1, we, the jury in this case, being duly impaneled sworn, do find the defendant Deontay Lewis guilty of aggravated murder in violation of 2903.01C of the Ohio Revised Code. Count 2, murder B, defendant is guilty, signed by all 12 jurors. With respect to the further finding of the offense of violence, he was guilty of felonious assault, signed by all 12 jurors. The further finding of permitting child abuse was guilty, signed by all 12 jurors. And endangering children is guilty, signed by all 12 jurors. Count 3, the defendant is found guilty of felonious assault, signed by all 12 jurors. Count 4, permitting child abuse, found guilty, signed by all 12 jurors. Count 5, endangering children, found guilty by all 12 jurors. Further finding he did cause serious physical harm under the further finding of endangering children. Count 6, guilty, signed by all 12 jurors. The further finding was in the affirmative, signed by all 12 jurors. Count 7, endangering children, found guilty, signed by all 12 jurors. The further finding was in the affirmative. He did cause serious physical harm, signed by all 12 jurors. Finally, count 8, tampering with evidence, found guilty by all 12 jurors. Counsel, Mr. Shaughnessy, do you wish to have the jury polled?
Once it's all heard.
Sure. Likewise, Ms. Longino, obviously, you want the jury polled. Collectively, ladies and gentlemen, is this your, juror number 1, is this your juror verdict as to both defendants?
Yes.
Juror number 2?
Yes.
Juror number 3?
Yes.
Juror number 4?
Yes.
Juror number 5?
Yes.
Juror number 6?
Yes.
Juror number 7?
Yes.
Juror number 8?
Yes.
Juror number 9?
Yes.
Juror number 10?
Yes.
Juror number 11?
Yes.
Juror number 12? Okay, the record should reflect that we do have the 2 alternates in the jury box. Obviously, they did not participate nor observe the deliberation process. but we did have them available if their service was needed. I want to thank you for your service in this matter. I will address you separately back in the jury room. All rise. This time, the defense will be remanded without bond. Sentencing is set for March, is it 20th? March 20th at 12:15.
Thank you, Your Honor.
Thank you.
During the sentencing, Judge Timothy McCormick described Day's actions as callous and emphasized the severe neglect and abuse Ania endured. Ania's father, Mikkel Garrett, who had been fighting for custody prior to her demise, expressed profound grief and called for justice for his daughter. Michael Amantulo, a white supremacist, received a life sentence for a racially motivated attack. The attack, which involved the fatal beating of a man in a public park, was described by prosecutors as a hate-fueled act of terror. Throughout his trial, Amantulo showed no remorse, using his time in court to express racist views and justify his actions. His sentencing was met with mixed emotions: relief that he would no longer be a threat, but frustration over his lack of accountability or regret. At the sentencing hearing, the victim's family gave emotional statements about the profound impact of their loss, describing how Amantulo's actions had devastated their lives. They called for justice, not only for their loved one, but for all who have been affected by racial violence. Despite the heartfelt testimony, Amantulo remained indifferent, his behavior showing the depth of his hatred and lack of empathy. The life sentence marked an important step in holding white supremacists accountable for their crimes. However, Amantulo's case also highlighted issues with addressing the spread of hate-driven ideologies. Experts argued that stronger intervention and education are needed to prevent individuals from adopting such beliefs. For the victim's family, the sentence offered some sense of closure, but the loss they suffered remains irreplaceable. While Amantulo's incarceration ensures he can no longer harm others, his case serves as a reminder of the ongoing fight against racism and extremism in all forms. On June 4, 2014, in the Shirley Hills neighborhood of Macon, Georgia, 49-year-old Hank Baker was discovered naked in a woman's yard. The homeowner reported that Baker attempted to assault her, but she managed to escape and call the police. Upon arrival, officers found Baker still on the property and took him into custody. In April 2015, following a trial in Bibb County Superior Court, Baker was convicted of attempted rape and battery.
Started lacking it when he told that absurd story about this lady attacking him. It didn't get any better when his blackout soon cleared up. Sold these things exclusively for the purpose of telling that absurd story. He didn't say anything compared to what he was doing. But on count one of this indictment, I find he guilty of 30 years in penitentiary. Do what? Do what, Big Brother? You want to hear count two, you want to do that after you leave? Count two, 12 months in the county jail and run concurrent with 30 years that we gave you on count one. That's up to the Department of Corrections. If it were up to me, the answer would be no. But it's not up to me. So they'll get to decide that. And I'll let it run concurrent with whatever you get in Barrow County. So where I'm living, you'll be too old to make a difference by the time you get out. Y'all take the record for this.
This case underscores the importance of community vigilance and the swift response of law enforcement in apprehending individuals who pose a threat to public safety. In 2014, Willie Frank Lyons Jr., 49, of Macon, Georgia, was involved in a tragic vehicular incident that led to the loss of his infant daughter and her mother. Lyons was charged with vehicular homicide and, upon conviction, was sentenced to 4 years in prison. During his sentencing hearing, Lyons expressed deep remorse for his actions, acknowledging the irreversible loss and the impact on the victims' families.
I apologize from the bottom of my heart. My intent was never ever to hurt Angela. My second one baby daughter, Kinsey. Sorry for this tragic accident. I'm so sorry. I pray that you guys will forgive me. Your Honor, I stand before you humble. I understand that this is the Lord and I have broken some laws, but it wasn't intentionally, it wasn't purposely. That was my family. I lost a child. I lost my best friend, somebody I had planned on spending the rest of my life with. And I understand how they feel. I truly do. I feel a million times worse because I constantly question myself, what could I have done that day to make a difference? But I stand before you now and I ask you for mercy and I pray that everybody will be able to move on. For me, this will forever be an open wound. There's nothing I can do to change it. I wish that I was not here with them, not here. I would ask God why. What is the purpose? What did I do? But I also understand that this is His will and what has to be done. I'm going to continue to give Him the praise. I ask you to be lean. I ask you to be just as you already have. But most of all, I ask that God have mercy on my soul. Because I feel that I'm going to have to pay for this if I'm worthy. Once again, I want to apologize to the family, and I pray all things will well be yours. Okay? Thank you.
The court considered various factors, including Lyon's prior criminal record and the circumstances leading to the fatal incident, before determining the sentence. He was sentenced to 4 years in prison for vehicular homicide. In March 2012, Brevard County Sheriff's Deputy Barbara Pill was fatally injured during a traffic stop in Melbourne, Florida. The incident occurred after Deputy Pill stopped a vehicle linked to a theft at a local motel. Brandon Bradley, the driver, fired multiple times at Deputy Pill, resulting in her demise. His passenger, Andrea Kirchner, was also present during the incident. In 2014, Bradley was convicted of first-degree premeditated murder and sentenced to death, following a jury's 10-2 recommendation.
Bradley, as to count 1, you are judged guilty of the crime of first-degree murder for the unlawful of Deputy Barbara Pill. For this crime, the court sentences you to be put to death in the manner prescribed by law. As to count 2, you are judged guilty of the crime of robbery. For this crime, the court sentences you to serve a term of imprisonment in the Department of Corrections for the state of Florida for a term of 15 years. As to count 3, you are judged guilty of the crime of fleeing or attempting to elude a law enforcement officer, siren and lights activated with high speed or reckless driving. For this crime, the court sentences you to a term of imprisonment in the Department of Corrections for the state of Florida for a term of 15 years. As to count 4, you are judged guilty of the crime of resisting officer with violence. For this crime, the court sentences you to serve a term of imprisonment of 5 years in the Department of Corrections for the state of Florida. These sentences are to run consecutive with each other. The defendant is entitled for credit for time served of 844 days as calculated by the clerk. You are advised that this judgment and sentence shall automatically be appealed to the Supreme Court of the state of Florida. Defense counsel is directed to perfect the appeal. The public defender is hereby appointed to represent you on appeal. Should you not have private counsel or are unable to afford private counsel, you are hereby remanded and without bail to the custody of the sheriffs of the Brevard County to be delivered for commitment to the Department of Corrections, where you will be confined until final execution of this judgment and sentence prescribed by law. Mr. Bradley, may God have mercy upon your soul. This court is now in recess.
However, subsequent changes in Florida's death penalty laws, which now require a unanimous jury recommendation for such sentences, led to the overturning of Bradley's death sentence. In 2021, honoring the wishes of Deputy Pill's family to avoid the trauma of a retrial, prosecutors agreed to a sentence of life in prison without the possibility of parole for Bradley. Andrea Kirchner, Bradley's accomplice, pleaded guilty to accessory after the fact of first-degree murder and other charges. She was sentenced to 12 years in prison for her role in the events leading to Deputy Pill's demise. On August 4th, 2013, during a wake in Macon's Village Green neighborhood, Quentin Jones fatally injured 35-year-old Stephen Johnson following an altercation. In April 2015, a Bibb County Superior Court jury convicted Jones of murder and aggravated assault. He was sentenced to life in prison without the possibility of parole.
Mr. Johnson, I'm sorry. I am Sandra Moore Malloy. My father was terminally ill and died. That's what we would have to see in the baby. Steve came to us the day my father died and said that he was sorry and he wanted to be there for us and said that he wanted to be a pioneer. I was doing the arrangement. I agreed with Steve to be a pioneer. Steve was never a bad person. He never disrespected anyone in our family. He was always a good person. He misunderstood why Steve was there and got angry.
Paying attention when I read that charge was here. You listen to what I was saying to them before they went out. Did you hear me when I told them that all of the circumstances of the killing show an abandoned and malignant heart? You hear that one? Killing somebody is bad enough. Going to a prison with the express purpose of killing somebody makes you the poster job for abandoned and malignant. That theory got it deep inside for me.
Jones appealed his conviction, arguing that the trial court erred by refusing to admit the first offender plea of a key state witness and by overruling his objection to the admission of his own prior conviction. The Supreme Court of Georgia reviewed the case and, in April 2019, affirmed the conviction, finding no abuse of discretion in the trial court's decisions. In August 2016, Shauna Smith, a 24-year-old mother and Amazon warehouse employee, tragically lost her life in southwest Atlanta due to mistaken identity during a gang retaliation. After her overnight shift, Smith was driving a coworker home when gang members mistakenly identified her car as belonging to their intended target. The gang, seeking revenge for a prior incident, opened fire, releasing 43 rounds from multiple weapons. Smith was struck by a bullet to the head, leading to her passing and a subsequent car crash. Following an investigation, authorities identified and arrested the perpetrators, using evidence like a cell phone left at the scene. In October 2019, Matthew Larkins and Trayvon Mack, two of the gang members, were convicted of murder, felony murder, and other charges. Fulton County Superior Court Judge Kimberly Esmond Adams sentenced them to life in prison plus 25 years, condemning the maliciousness, callousness, and recklessness of the crime.
The sentence, as Mr. Bowles pointed out, the court is required to impose. As to your conviction for murder, the court doesn't have a choice. The sentence that I am required by law to impose is a life sentence. And I will tell you that even if I was not constrained by the law in this matter, I would still give each of you a life sentence, because Ms. Smith will never be able to spend time with her daughter, watch her grow. Her 4-year-old daughter is left to be raised by her grandmother, who should be able to enjoy having a grandchild and not be forced to raise her. She never saw this coming. She had no idea because there was no reason for her to, no involvement. The evidence was that there were 8 different firearms on the scene. There were 5 people in 2 cars. I don't know who had what. I don't know if everyone had, but the evidence in this case, I believe, establishes that the 2 of you did. And it is unfortunate that this situation is going to result in the kind of sentence that is required to be imposed when a person is convicted.
Smith, an innocent victim, was remembered as a hard-working mother whose life was senselessly taken. 2012, in Sheffield Village, Ohio, 26-year-old Royce Kowalczyk, while impaired, caused a head-on collision that led to the tragic loss of Terry Martin, a Cleveland clinic nurse. At the time of the accident, Kowalczyk was out on bond for a previous drug-related case. In February 2013, Lorain County Court Judge James Maraldi sentenced Kowalczyk to 6 years in prison for aggravated vehicular homicide, imposed fines totaling $11,375, and revoked his driver's license for life.
Probably got away with many times without there being any consequences to anyone but himself. And because it happened so many times that maybe he'd be using drugs or partying with somebody, with a friend, or by himself, he'd go about his way and never hurt anybody and think, well, nothing bad happened that time, so nothing bad's gonna happen again. That was like playing Russian roulette. And in this case, the chamber was filled in this one day. And this time, when you thought nothing was going to happen to anybody else or didn't care about whether anything was going to happen to anybody else, something did happen to someone else. In any event, this case has tragic proportions beyond all measure. I can say in reviewing it in preparing for today, that I read every letter, every email that was sent. There were some that I think probably were done after seeing someone else's email and then kind of signed their name to the same email, but I think they were probably they all came to me heartfelt, the people who felt an emotional tie to the victim.
Mr. Martin, I could never ever begin to understand the scars I've caused to you as a husband. To lose your best friend and your wife, Terry Martin. I couldn't imagine all the pain and suffering I've caused to your whole family. I can only hope for when you think of her, you think of how much of an amazing person she was and all the amazing, joyful experiences you shared with her. All the people she helped save out of her job at the hospital. She was truly a blessing to society. It's important that you think of those times with her, when her name is brought up, rather than how it was brought to an end. I do want you to know that I do take full responsibility for Terry Martin's life, physically and consciously. There isn't a night that passes that I don't pray for your whole family. Terry Martin's life was taken recklessly by me, and she will never be forgotten. I assure you that this tragedy will remain in me always and forever in every aspect. Thank you for letting me speak.
Terry Martin's husband, Olin Martin, a Lorain County narcotics detective, expressed profound disappointment with the 6-year sentence, considering it insufficient for the loss of his wife.
To make a quick phone call, to share a story, ask a question, or merely say that I love you. I've been robbed the holidays, robbed a few things together, days together on our boat, robbed of sharing that moment when our youngest daughter Julia graduates from college, gets married, has a grandchild, or when Miranda has her first child. We've been robbed of that by you. I could go on and on about the changes in my life, physical, mental, and spiritual. But quite simply, the love of my life, best friend was robbed from me by you, Royce Kowalczyk. And I'm now destined to holding on to emotions of days gone by, of and sounds, tastes, and days that remind me of all that's been ripped from my life. On March 2nd, I started my day like any other day. Waking to share morning coffee with my wife, Terry. Watch the news together for an hour before we prepared to leave for work. But March 2nd was significantly different for us that day in that we were enjoying our fifth morning in our new home together here. Since Terry had been able to move here from our home in Columbus and had started a new job at the Cleveland Clinic. It was our new adventure and an exciting time for us. Terry and I had been married nearly 10 years. I celebrated my 10th anniversary without my wife.
And my sentence must be proportional to not just the damage, because there are so many people that we see who are as a result of criminal activity. This is as tragic as any. In some ways more tragic because the victim was such a wonderful person. Under the law, the issues that I must deal with also include that the facts of this case, Mr. Cruelty was actually getting treatment before the second, after his first arrest and brought to this court. I have to rely on the facts and not hearsay as some of the information may have gotten out to the public. He wasn't out on probation in this case when he did what he did. He was a drug addict, and he was a selfish drug addict, as drug addicts are. And this is the kind of damage they do. But when I look at the Raylich case, not too long ago, I think the facts in that case were much worse. The result wasn't worse because of death had been involved. And I'm not trying to measure one life versus another. But I know that in the Raylich case, the defendant was nearly three times over the legal limit, driving at a high rate of speed, leading the police on a chase. That's terrible. You weren't far behind what you were doing. You may not have been as conscious as the actions of Mr. Raylich, and that maybe goes more to the extent of criminal intent. His first case, Mr. Cruelty, 11 CR 084127. Had you not gotten in any further trouble, you would have probably qualified for intervention because you were not a repeater, you were not a violent offender, you were not a repeat felony, or you had not committed a felony in the past. You would have qualified for probation. It's not happening. Again, on consideration of all matters set forth by law that I am required to follow, is the judgment of law and sentence of the court the defendant be sentenced as follows. On count 1, 5 years at the Learning Correctional Institution and a fine of $10,000. Count 2, merged, no sentence. Count 3, 1 year at the Learning Correctional Institution. Counts 4 through 8, no sentence. On count 9, there's no sentence on count 9 either. It's out been merged as well. All counts in this case are consecutive and concurrent to the sentences in the two previous cases. Upon your release from prison, there will be 3 years of mandatory post-release.
Prior to the sentencing, he initiated a letter-writing campaign, urging the judge to impose the maximum sentence of 13 years, reflecting the community's desire for a harsher penalty. In November 2013, 16-year-old Dontavius Man Mintz was involved in 2 serious crimes in Macon, Georgia. On November 18th, Mintz and an accomplice broke into the home of a local dentist in North Bibb County. They robbed the homeowner and took him hostage. On November 21st, Mintz participated in a drive-by incident targeting 16-year-old Damian Bernard Little Petey Clayton near the intersection of Cedar Avenue and Mosley Street in Macon's Unionville neighborhood. During the incident, Alyssa Jackson, also 16, was fatally struck by a bullet. Clayton survived the attack. Mintz was arrested and charged with murder and armed robbery. In 2015, at the age of 18, he pleaded guilty to the charges and was sentenced to 2 concurrent life sentences with the possibility of parole.
Yeah, we just ask the court to take note of the strong family support this event has. If they were to address the court, they would just talk about how much they love this event. I believe they understand that nothing they say can persuade the court to do other than follow the joint recommendation. If the court would not inclined to do so, it would be worse. So we would ask the court to follow the recommendation.
Mr. Mint, did you go to the other board, Mr. Christian, if you did in the probation, you were right on that, you were that. I don't know, the probation, particularly out there, and stuff, if they want to play with it. Nothing at all. You got a lot of family. Just get it turned out. A lot worse. You would say that. It's going to be very good. Very fine life. I would let you. Or just get it done. I'll paraphrase the last line. It is far, far better than anything you do now. You get better done. So we're counting on the good on the Greek level. I'm not going to give you that. Don't get me get it's going to be life. On count two, it's that those lives that are going to go over. I'm not going to give you that. It's going to be life.
While serving his sentence at Ware State Prison, Mintz passed away in August 2021 under circumstances that remain unclear. His demise is part of a broader investigation by the U.S. Department of Justice into conditions within Georgia's prison system, focusing on issues such as understaffing and inmate safety. On February 22, 2014, in Macon, Georgia, 45-year-old Jacinto Flowers fatally injured his estranged wife, 38-year-old Bridget Flowers, as she sat in her minivan. The incident occurred just days after a previous assault on February 14, 2014, where surveillance footage captured Jacinto punching Bridget in the face at a Walmart on Gray Highway, rendering her unconscious. Following the Walmart assault, Jacinto was arrested, but released on bond within 2 days. Family members later revealed that despite bond conditions prohibiting contact, Jacinto continued to harass Bridget. Tragically, on February 22nd, he approached her vehicle and struck her in the face at close range, resulting in her immediate demise. 2 other individuals present were also injured during the incident. During the trial, key evidence included the Walmart surveillance video and testimonies from Bridget's children, who witnessed the murder. The jury found Jacinto guilty of malice murder, felony murder, and 4 counts of aggravated assault. On July 1st, 2015, Judge Howard Sims sentenced him to life in prison without the possibility of parole. Judge Sims remarked on Jacinto's criminal history, noting a prior life sentence in 1992 for drug-related charges, from which he was paroled after approximately 9 years. The judge expressed that granting parole had been a mistake, suggesting that if Jacinto had remained incarcerated, Bridget's demise might have been prevented.
I remember you in 1992. You, Mary Alice Moore, 2 of your brothers, I don't know if you had any other brothers, but I know Edward, Henry. Y'all used to serve over on the east side of Clarence Park. Well, the jury found you guilty of selling dope on the east side of Clarence Park after you'd already been convicted one time in a dope case. And you got sentenced to life. When did you get out? When did you make parole on that license? 2001. You did 9 years on the license. 10 years and 6 months. They gave you credit to jail time, right? Yes. In my view, the thing that you would have made a mistake when they paroled you on that license. If they happened, the one was probably still alive.
state doesn't have an opportunity to make that mistake for a second time. I believe that in this case, the law requires me to sentence you to life in the penitentiary without the possibility of parole. So that there's no confusion down the road. If it didn't require me to do that, I'd do it. I believe counts 1 and 2 of the indictment merged for purposes of sentencing. On count 1 of the indictment murder, I sentence you to life in the penitentiary without the possibility of parole. On counts 3 through 6, I sentence you to 20 years in the penitentiary on each count. They'll run concurrent with one another, concurrent with the sentence of number 1. You understand all that? Yes. Any questions?
In 2020, the Supreme Court of Georgia upheld Jacinto's conviction, rejecting appeals that challenged the admissibility of prior altercation evidence and autopsy photographs. The court found no reversible error, affirming the life sentence without parole. Thank you so much for watching. Don't forget to subscribe and hit the notification bell so you can stay updated with our latest videos.